Hello and welcome to the new session of Current Affairs by Mentora IAS. I am Safir, your faculty for Geography, and in this particular session we are going to talk about the current affairs which will be related to Polity, Science and Tech, International Relations and Geography. So in today's current affairs, what we are going to do is that we are going to discuss a pretty interesting argument that is basically going on between center and the states. Okay, then we'll be moving towards a very important mission for India, that is Mission Gaganyaan and some of its recent achievements. Then subsequently we will be moving towards one of the most important ways of hacking privacy of people through spyware, and subsequently we'll be ending with the equinox, that is basically the date for today. That today is the autumnal equinox, so we'll be talking about it and we'll be ending this particular session. Now, these particular sessions are completely free of cost. So if you like this particular effort, please like, share and subscribe, and subsequently at the same time do check the description where you are going to find a detailed handout of whatever is going to be covered in this particular class in order to assist your notes. तो आज के ये पूरी की पूरी डिस्कशन जो है, this is going to be on the various fronts of polity. ज्योग्राफी का कुछ टॉपिक है, साइंस एंड टेक है, और थोड़ा सा हमारे पास स्पाईवेयर से रिलेटेड हमारे पास यहाँ पे चीजें रहेंगी. तो इस पूरे के पूरे डिस्कशन में मेरा ये ऑब्जेक्टिव रहेगा कि मैं आपको पहले तो फंडामेंटल समझाऊं, और फंडामेंटल समझाने के साथ मैं आपको ये भी बताऊं कि हाउ एग्जैक्टली आर यू गोइंग टू यू कैन से अप्लाई दीज पर्टिकुलर थिंग्स. सो वी आर गोइंग टू लिंक अ लॉट ऑफ थिंग्स दैट वी रीड इन द जीएस विथ व्हाट वी आर गोइंग टू डू राइट नाउ विथ रिस्पेक्ट टू करंट अफेयर्स. ओके, सो लेट अस बिगिन दिस पर्टिकुलर सेशन. और इसका सेटअप ही कुछ ऐसा रहेगा कि पहले आपके पास मैं 2 क्वेश्चंस दूंगा. ये 2 क्वेश्चंस में आपका टास्क ये है कि पूरी की पूरी वीडियो में आप उसका आंसर ढूंढेंगे, और फाइनली जब उस क्वेश्चन को सॉल्व करेंगे तो आई रियली होप कि आपको वो क्वेश्चन का आंसर खुद ब खुद मिल जाए. ठीक है, सो व्हाट यू आर गोइंग टू डू इज दैट आई विल बी पुटिंग फॉरवर्ड 2 क्वेश्चंस और अ क्वेश्चन विद एवरी पर्टिकुलर टॉपिक, सो दैट इन द बिगिनिंग इटसेल्फ योर ब्रेन इज अट्यून्ड दैट यू हैव टू फाइंड दिस पर्टिकुलर आंसर विद इन दिस पर्टिकुलर सेशन. Okay, so let us begin this particular session, and we are going to discuss this in a very you can say comprehensive manner with respect to whatever is required and what is required with the level of UPSC. So nothing is going to be untouched, and subsequently what you can be talking about is that how exactly are we going to talk about the entire UPSC syllabus and coverage. So what you are going to get here is that what is the depth till which you have to cover a particular thing. Okay, there are pretty technical topics here, just like if you talk about GANX, you talk about spyware. These are pretty technical topics as well, but what is required for an aspirant of UPSC, that is what we are going to touch upon. Okay, so let us begin with the very first one, the one which comes from Indian polity, and this has been a raging issue because it is an issue of federalism, it is an issue of division of power, it is an issue of the rights of the state versus the powers of the union. Okay, and this is something which we are going to study with respect to a very interesting peculiar case, that is the presidential reference that has been taken up by the Supreme Court. Okay, so we are going to talk about a lot of different things here. We are first of all going to discuss what exactly is the backdrop of this particular presidential reference, what exactly is the case that prompted this particular presidential reference. Then we are also going to talk about how exactly the presidential reference is something that is related to the powers of the governor and the president. We are going to talk about how the states can make laws, and subsequently we are going to end up with a discussion on the Supreme Court of India. Okay, so let us discuss this particular session in its entirety. Okay, that the presidential reference has been given to the Supreme Court, and the Supreme Court recently has actually finished its hearing. But before we get into that, I would want you to look at this particular question. Okay, very carefully read the question, its statements, and subsequently the options. Okay, so you may pause the video now and subsequently read the question. Take your time reading the question, understanding it, what exactly is the directive of the question, and then subsequently you have to choose the right answer. So you may pause the video now. Okay, now this is the second question that I would want you to see. Okay, and again read the question well, and after reading the question well, then understand what exactly is the answer to this particular question. Okay, you may pause the video now. Okay, now let us talk about what exactly is there in the news, why we are talking about this particular question. Okay, so recently the Supreme Court of India has concluded the hearings which are related to the presidential reference that has been exercised by President Draupadi Murmu with respect to a particular case on which the Supreme Court has recently announced a verdict. Okay, now with respect to this particular case, when I talk about it, so the Supreme Court has been given this presidential reference. Okay, so presidential reference is basically a way through which the president actually asks certain questions of law or fact that are of public importance and that have not yet been covered by any of the Supreme Court verdicts or decisions. Okay, so presidential reference is something which is given under Article 143 of the Constitution of India, and with respect to this particular article, the presidential reference that has been given to the Supreme Court as of now has been done under the exercise of the power of the president given under 143 clause 1. What exactly is it? We are going to discuss, don't worry. Okay, so based upon this particular reference, the president has actually posed 14 questions of law in front of the Supreme Court, which are prompted by the verdict of the Supreme Court that was given in this particular case, the state of Tamil Nadu versus the governor of Tamil Nadu. Okay, with respect to this particular case whose verdict was given by the Supreme Court, and this was something which actually radically changed the interpretation of the Constitution with respect to how the bills are going to be passed or assented. Okay, that is something which actually changed the dimensions of what exactly are the discretions and what exactly are the obligations of the governor. So we are going to discuss that in this particular session. First of all, let us break this question down logically. In order to understand this particular news, it's very important that first of all we understand what exactly is the case. So TN here stands for Tamil Nadu. Okay, it is called the state of Tamil Nadu versus the governor of Tamil Nadu case, decided in 2025. Okay, now what has happened is that between 2020 and 2023, okay, between 2020 and 2023, the state of Tamil Nadu, that is basically the Tamil Nadu government, they basically have passed 12 bills. Okay, 12 bills pertaining to powers of appointing vice chancellor. Okay, vice chancellor of the universities. And it basically sought that this power of appointing the vice chancellors for the university, first of all, will be with the state government and not with the governor. The second thing that this particular bill talked about was the introduction of a government nominee in the committee which is going to look for the vice chancellor candidate. And third, that it basically wanted to overhaul the entire system of the financial management of the universities, where the finance secretary would basically be introduced as one of the members in every such committee. Okay, so there were certain issues with respect to this. There were 12 such bills which were passed by the state legislature, and subsequently they were presented to the governor of the state for assent. Okay, now out of these 12 bills, all the 12 bills were kept pending. Okay, all 12 bills were kept pending. And when they were kept pending, that basically meant that the governor did not give assent. The governor withheld the assent. Okay. So following this, what the Tamil Nadu government did, it repassed some of these particular legislatures in the state legislature, and subsequently again presented it to the to the governor of the state for their assent that this bill has been properly reconsidered by the house, and the house finds it fit that the bill is something which should be given assent to it become a law. Now basically what happened was that the governor still took no action. Okay, so after this what happened was that the Tamil Nadu government now sued the governor. Okay, so now because of this entire event, now it is the Tamil Nadu government, okay, government of Tamil Nadu goes to Supreme Court, okay, and it actually sues the governor of the state. Okay, and it alleged that the governor of the state has not been acting in a manner which should be you can say helping the entire governance, or for that matter the government of Tamil Nadu, to run in accordance to the provisions of the constitution. Now this is one of the things. The second thing which the Tamil Nadu government also said with respect to its petition in the Supreme Court was that it had recommended some of the appointment of the members of the Tamil Nadu State Public Service Commission to the governor, to which the governor has not yet taken any action. Now the State Public Service Commission of any particular states are actually appointed, the members of this are appointed by the governor. Okay, so the chairperson and the members of the State Public Service Commission are to be appointed by the governor, and subsequently the governor is supposed to be acting on the aid and advice of the Council of Ministers headed by the Chief Minister. Now this is constitutional provision. That was the second thing that this Tamil Nadu government came up as a grievance with respect to the Supreme Court. So as soon as this particular case was launched in the Supreme Court, at that particular time the governor, after a few days, changed his stance and subsequently gave assent to 2 of the bills and reserved the rest 10 for the consideration of the president. Okay. So now technically the point is that first of all this bill has been pending for over 3 years. Then the next thing was that before the action of this government with respect to this particular bill at the Supreme Court, the governor was not acting upon it, and immediately after the action the governor actually took this step that it is to be reserved for the further consideration of the president. Now this entire thing was actually said to be ultra vires of the constitution. That basically means that this is illegal and this is a deliberate impediment to the will of the people. Now why exactly is this a deliberate impediment of the will of the people? Let us also understand that. Okay, now this particular case is very important with the aspect of the government which is popularly elected. Okay, a popularly elected government versus the titular head of the government, titular or nominal head of the government. Now this actually became the main issue. Okay, now why exactly this became the main issue? Because when you talk about the popularly elected government, now this government is elected based upon the legislative assembly elections, which is called the general elections. Okay, legislative assembly elections. So based upon the legislative assembly elections, whichever party secures more than 50% of the seats in the legislative assembly of that particular state is basically going to form the government. So technically, if you are securing a majority on your own as a party, it means, it is an indication that people want you to run the government. Okay, so this majority is something which is seen as people's will. People's will for running the government. So that is why it is called a popularly elected government. Now with respect to the titular or the nominal head of the government, now this is basically in reference to the governor of a state. Okay, now the governor is basically appointed by the President of India. Okay, so the governor is not a elected individual. He or she is not an elected individual. This is an appointed individual. Okay, appointed by the president. And when the president is going to appoint a particular individual as the governor of a particular state, it means that the president is acting under the aid and advice of the Central Council of Ministers headed by the Prime Minister. Okay, so that is why the governor basically is the authority that has been vested with the executive power of the state. Okay, so governor actually is vested with the executive power of the state. Okay, so any action or any decision that has been taken by the popularly elected government, so that particular thing has to be implemented in the name of the governor. Now this is the setup. Okay, executive power of the state. Further, at the same time, it is also the governor of the state who has been given the power to provide assent to the bills that have been actually passed or cleared by the popularly elected, you can say, legislature. Okay, so it is a legislature whose job is to make laws. Okay, so this legislative assembly basically is going to make laws. Okay, the governor basically is the individual who has to provide assent, and then subsequently it is the government. Okay, it is the government whose job is to implement the laws. I think this is something which is pretty clear. Okay, but this implementation of the laws are going to take place in the name of the governor. This is the entire scenario with respect to the popularly elected government and the nominal head. Now, the constitution also rests some of the provisions with respect to the governor with regards to the assent. Okay, we are going to discuss that as well. But before that, let us first of all understand clearly what exactly was the mismatch here. So if you have understood this particular mismatch, that it was basically an elected government that was actually fighting for its rights with respect to you can say a governor who was withholding the bills. Now this was something which was seen by the Supreme Court as illegal. Okay, erroneous and illegal. This is something that the Supreme Court found to be erroneous and illegal. Further, the Supreme Court first of all said that with respect to the laws or the bills that have been presented to the governor in order to you can say provide assent. So that is something which is done under Article 200. So with respect to that particular assent, we have to understand that under Article 200 there is no concept of a pocket veto or an absolute veto. Okay, why are we saying this? I am going to come to that as well, don't worry. Okay, the next thing, because there is no timeline that has been given in Article 200 for taking of the action with respect to the governor, it does not mean that the governor can hold any bill indefinitely without taking any action. Okay, so subsequently, because of this particular tendency that the governors are holding bills without taking any action, which is virtually the definition of pocket veto, there needs to be some kind of definition or there needs to be some kind of framing of guidelines that need to be done. And that is why the Supreme Court actually prescribed certain guidelines to both the governor of the state as well as the President of India in order to take the action in the cases which have been presented to them under Article 200 and 201. So let us now understand what exactly have been the timelines that have been provided. Okay, so first of all, we have to understand that there are two ways that the governor can act. Okay, now with respect to the governor can act in two ways. Okay, the first way is basically on the advice of the State Council of Ministers. Okay, and second, contrary to the advice of the State Council of Ministers. Okay, this is the first thing. Now, what is to be done if the governor is acting on the State Council of Ministers, okay, and subsequently the governor is withholding assent for reconsideration. Okay, so withholding assent for reconsideration of the House or the legislature. Now if this is to be done, okay, that is to be done within 1 month from the date of presentation of this particular bill for assent. The second thing, reserving for the consideration of the President. Okay, if this is to be done again on the advice of the State Council of Ministers, this also has to be done within 1 month. Okay. Now, there may be a case that in both of these situations, withholding the assent for reconsideration of the House or reserving it for the President, but you are doing this on your own. Okay, you are doing this on your own discretion and contrary or contradictory to the advice of the State Council of Ministers. So in that case, you will be having 3 months. Okay, there will be a time frame of 3 months to declare either reconsideration of the House, okay, either for reconsideration of the House or for that matter reserving for the President. Okay, for the President. Okay, you cannot be doing this in any other way. Now, the second thing, if in the case of reconsideration by the House, if that particular bill is passed, okay, if this particular bill has been passed again, so in such a situation, the governor is obligated to give this particular assent within 1 month of the repassage of the bill and presentation for assent. Okay, now that's the next thing that we need to understand. So these were basically the timelines which were prescribed for the governor under Article 200, that you have to act within these particular guidelines or timelines. Okay, now with respect to the President, okay, with respect to the President as well, for Article 201, okay, if a particular bill has been reserved for the consideration of the President, so in that particular case also the President has to abide by a timeline. The President has to abide by a timeline. Okay, the President cannot indefinitely withhold the bill. Okay, if the President declines, if the President withholds assent or declines assent, okay, so in that particular case, proper reasoning has to be provided. Okay, so this was basically seen as an attack on the discretion that was provided by the Constitution to the Governor and the President of India. Okay, so these timelines that were actually set up by the Supreme Court and also the instructions that if you do not do this, you also have to provide for an explanation. Now this was something which prompted the Union government to go for you can say a presidential reference. Okay, so now when we talk about the presidential reference, so the presidential reference is given under Article 143. Okay, so Article 143 of the Constitution of India provides the power to the President of India to consult the Supreme Court for its opinion. Okay, so this is basically President's power to consult the Supreme Court. Okay, so I am writing Supreme Court as SC. Okay, Supreme Court on a question of law or fact that is currently or in the future may become a matter of public importance. Okay, that's the first part of it. So this is called clause 1. Okay, so the President may consult the Supreme Court on any such issue which may be a matter of fact, a question of fact or a law that holds public importance for the first thing. The second thing is that this particular public importance is not currently found in any of the judgments, observations or rulings of the Supreme Court, and the President feels that the opinion of the Supreme Court must be solicited. So in this particular scenario, the Supreme Court may, Supreme Court, after considering the matter, may report back to the President. Okay. Now this is clause 1 and it is under this particular clause. Okay, it was actually under this particular clause that the current presidential reference was given. Okay, and here I would like for you to notice this particular word may. Okay, now the second thing, Article 143 also has a second clause. Article 143, but now clause 2. Now this basically relates to a matter given under Article 131. Okay, and is a question related to the, it is a question which is related to the pre-constitutional treaty or a sanad. Treaty, agreement or a sanad or any such other arrangement. Okay, so this particular question may also be given to the Supreme Court to evaluate. So in this particular question, the Supreme Court has to advise the President. Very important. Okay, and what I would like for you to notice is how the wordings have been different. Okay, so in clause 2 of 143, it basically is something which has to be provided by the Supreme Court. So this is something which is mandatory. So any such presidential reference which has been actually given under Article 143 clause 2 has to be mandatorily advised to by the Supreme Court. Okay, but at the same time, when we go back to 143 clause 1, here we basically have another word, and that is may. Okay, so it basically means that in such a case, the Supreme Court is not bound to advise and may decline. So in this particular case, the Supreme Court may or may not advise the President of India on the matter that has been referred to it after a due hearing has been given. Okay, so this is something that we need to understand, that not all the presidential references that have been given to the Supreme Court, they will be answered or advised to by the Supreme Court of India. Okay, now that is the current interpretation of this particular article that as it stands. Okay, now in the current case, when we talk about the presidential reference that was given to the Supreme Court with respect to this particular case, so here the Supreme Court has actually heard the entire case, it has concluded the hearings and it has reserved its opinion. Okay, so when the Supreme Court actually reserves its opinion, it basically means that the verdict has not been pronounced. Now the Supreme Court is going to deliberate amongst its justices. They are going to deliberate upon what is to be done, what are the merits and what are the merits of the various arguments, and subsequently they will be coming up with the verdict if they have to, or they might decline as well. Okay, so there have been at least 2 occasions in the past, one in the Ram Janmabhoomi case in 1993 when the Supreme Court actually declined to give its advice to the President. Okay, so I hope this is something which is clear. Now let's get ahead. That what exactly have been the questions of law that have actually been raised with respect to the presidential reference. Now these 14 questions, I am not going to show all these 14 questions, but we are going to take an overall gist of what exactly these questions have been talking about. The first thing, what exactly are the powers and limitations of the governor of a state with respect to Article 200? So we need to define the contours of the constitutional powers as well as limitations given under Article 200. Then at the same time, the decisions that are basically given by the governor and the president of India under the powers to be exercised of given by Article 200 and 201, how exactly are they related to judicial review? Because when you talk about the judicial review, now this is something which evaluates the you can say any malified intent or the correctness of the implementation, if the procedure of the law has been followed in the proper sequence or not. That is something which basically is judicial review all about in the crudest manner. We are not going to get into detail of that. It may become very wide as a you can say a discussion as of now. So judicial review is basically the judicial evaluation of what exactly was done by the governor or the president. Now this is something which is asked based upon the immunity which is given under Article 361. So under Article 361 of the Constitution of India, any act that is done by the President of India or the governor of a state in the exercise of their duties, okay, that cannot be called upon to be questioned in a court of law. So this particular question actually impinges on that particular subject, that the actions that are taken under Article 200 and 201 by the governor or the president, as the case may be, is it open to judicial review? Because we have Article 361 which negates this. Okay, then the next thing is that can the judicial orders regulate the extra constitutional exercise of constitutional powers or procedures? Now this particular question has been asked because the Supreme Court of India in the case of Tamil Nadu gave a verdict under Article 142. Okay. Now with respect to Article 142 of the Constitution, it is basically Supreme Court's power. Okay, Supreme Court's power to dispose of any matter. Dispose of any matter pending before it by issuing a decree. That will have the force of law throughout the country. Okay. Now this is something which is very, very important for us to understand, that with respect to this particular concept, Article 142 is basically one such extraordinary power that is there with the Supreme Court, vested by the Constitution, that in case if the Supreme Court finds that there is any kind of gross injustice that is being done and that matter is pending, that is basically being considered in the Supreme Court as of now. So in that particular scenario, the Supreme Court can issue orders, okay, which are going to first of all deliver complete justice to the situation, and second, these orders are to be respected in the same manner as it is respected with respect to the law made by the Parliament. So the way in which the Parliament makes the laws and the respect and the authority that is given to it, the Supreme Court's order have to be given and respected in a similar manner throughout the country. Okay, so Article 142 was invoked by the Supreme Court in this particular case with respect to the state of Tamil Nadu, and subsequently under Article 142 of the Constitution of India, the Supreme Court gave two things. The first thing, that with respect to the withholding of the bills with the governor, that the governor was sitting on the bills indefinitely. Now this was something which was erroneous and at the same time this was illegal. So at that particular moment, the Supreme Court gave assent to 10 of the bills which were at that particular time pending before the governor and the president of India. Okay, so based upon Article 142, the Supreme Court gave it deemed to be assented all the 10 bills pending for assent. Okay, so for the first time in the history, there has been a case that the Supreme Court, based upon a judicial order, gave assent to the bills which were not its territory. Now this was something which was the territory of the executive, particularly the governor and the president of India, but these pending assent was deemed to be assent by the Supreme Court under Article 142. Subsequently, these bills were the ones which were enacted as laws, and these were notified by the Tamil Nadu state government. But this also prompted the debate that is the judiciary in its overreach while it gave this particular order. And that is why these questions of law were actually framed and raised in such a manner. Okay, then at the same time it was also said that can the judicial orders actually regulate such constitutional provisions? Okay, and at the same time, if there are timelines or the ones which are not specified, what would be the manner of implementation? Okay, then at the same time, what is the scope of the Supreme Court's advisory? Okay, and subsequently, what exactly is its constitutional jurisdiction? Is it something which is related only with the procedure of the law, or is it something which is going to evaluate the substantive portion of the law as well? Okay, so what is contained in the law? How does the state bill become a law? Okay, and if it becomes a law, is there any kind of intervention that can come from the court side? Because when you talk about the function of making law, that is the function of legislature. The function of implementing the law is the function of executive. But the point is that can the judiciary actually take over this particular procedure as well? So this is basically where the judicial overreach concept has been invoked. Okay, and subsequently, what is the scope of Article 142? And does this have the power to supersede the powers that have been given to the governor or the president? So the 14 questions that were given can be jotted down to these questions as the questions of law. Okay. Now, going to how exactly an ordinary bill becomes a law in the state legislature. So when we talk about this particular thing, we have to understand that first of all we are talking about an ordinary bill. So ordinary bill basically means that this particular bill is the one which will not include money bills. Okay, so any bill which is except the money bill. Okay, that is basically called and certain financial bills, they are basically the ones which are called ordinary bill. Not include money bills, and for clearing the confusion I would also say some financial bills. Okay. Now this is something which needs to be discussed, that how exactly a particular bill becomes a law. So bill is basically a legislative proposal to initiate the proceedings for this particular proposal to become a law in order to regulate a particular unregulated or previously regulated article or power. Okay, so let us say that currently we would want to in some way you can say regulate cryptocurrency. Okay, so cryptocurrency is something which has not been listed under any particular you can say list of the Constitution of India with respect to the separation of powers. Okay, but the point is that this particular aspect, cryptocurrency, is as of now unregulated in the country, and you would want to regulate it. So if you want to regulate it, how would you do it? You basically have to come up with a proposal in front of the appropriate legislature. In that particular case, it will be parliament. And then subsequently, once you are in the parliament, now what is going to happen? You will have a complete discussion of what exactly is your proposal, how do you want to regulate it, what would be the mechanism, what would be the authorities, what would be the punishments for any kind of violation or breach. Okay, and subsequently this will be considered. And that is how a particular bill becomes a law. So when you talk about such a thing with respect to a state legislature, so the first phase is always introduction. Okay, so with respect to the introduction, it is basically where this particular bill can start. So with respect to the state legislature in the country, there are two types of state legislatures. Okay, so first of all, let me also tell you what exactly is the legislature of the state. So when we talk about state legislature, So it has got two formulae. Okay, so the state legislature is first of all governor plus legislative assembly. Or it could be governor plus legislative assembly, and then subsequently what we also have is basically a legislative council. Okay, so in the second case where you basically see that there are two houses, okay, there are two houses of legislature, okay, this is basically called a bicameral legislature. It's a bicameral legislature. It basically means there are two houses of the legislature. Even the Parliament of India is bicameral. We have Lok Sabha and the Rajya Sabha. Okay. Now the first case is basically called the case of unicameral legislature. Okay, uni is one, so unicameral legislature. Now this is basically the two ways in which we basically have the state legislature set up in the country. Some of the states have got two houses, that is bicameral. Some of the states have got just one house, and that is why the members of this particular assembly are called MLAs, Member of Legislative Assembly. Okay, now they are the ones who are popularly elected. Now talking about the stages of how a bill becomes a law. Okay, so it starts as a bill. Okay, now bill needs to be introduced. Okay, introduced in the house. So as of now I am not talking about the kind of bill that we have, private member or public bill. We basically have a bill which needs to be introduced to the house, and it could be any house. In case of a bicameral legislature, it may be legislative council or the legislative assembly, and for unicameral legislature it is driven. Okay, the first would be introduction of this particular bill to the house. Now when the bill is introduced at this particular time, only the title and objectives are read out. Okay, what exactly is the title of the bill and subsequently what this bill seeks to achieve? That's the first thing that you are going to do. The next thing after this is basically that there may be a resolution. Okay, resolution is a way in which the parliament or the legislature decides what exactly is to be done, what are the orders. Now based upon this particular resolution, it may be resolution for you can say referring to a standing committee of the house. Okay, once this is done, so after that what happens is that we have to see if this particular resolution passes or fails. Okay, if it passes, so then it is referred to the standing committee. Okay, and if it fails, so in that particular case what is going to happen, that the house considers the bill. Okay, now what exactly is the difference when the bill goes to the committee? So at that particular time it is the committee which takes up a detailed discussion. Okay, but if it comes to the house directly, it is the house which is going to take a detailed discussion. Okay, so ultimately what happens is that this particular committee's report is also going to be tabled in the house. Okay, even if it goes via the committee, it is going to come to the house, and when the house considers this bill, this is where you basically are going to find the debate. Okay, debate on the provisions, and then at the same time amendments proposed. Okay, so if there are any amendments that have been proposed, so they are basically the ones which happen at this particular time. This is the detailed discussion. Okay, now what is going to happen after this entire thing has been done? Now it will move to the next phase. Okay, now this is going to be taken up for voting. So at the part of voting, now the bill has achieved its final you can say design. Okay, whatever was the initial design, and after the debate, whatever has been the design, has any amendment been accepted, or for that matter has the bill been considered in its original form, now it is passed for voting. So in voting, what basically needs to happen, either it passes or fails. So if it has to pass, it basically needs a simple majority. Simple majority basically means greater than 50%. Okay, so this basically means, this will mean greater than 50% of the members present and voting. Okay, so when the members present and voting are more than 50% at that particular time, the bill passes. If the bill fails, the bill is ending. Okay, so this basically means end of the bill. It will not become law. Okay, now in this entire particular thing, if it passes, then it goes to the governor. I am just writing GUV for the governor as of now. Okay, now when it goes to the governor, now governor has three options. Okay, the governor has three options: provide assent, withhold assent, return the bill for reconsideration, or reserve the bill. So when it is reserved, it goes to the president. Okay, so governor has four options to choose from. If the governor gives the assent, if the governor provides the assent, it becomes a law. That is how a bill actually becomes a law in the state legislature. Okay, so that is something that we need to understand. So when the assent is, when the bill is presented for the assent, that is basically done through Article 200 with respect to the state legislature. So under Article 200, it is the governor. Okay, it is the governor to whom this particular bill is presented for assent. So now the governor basically has got these options to exercise that we have just seen. Provide assent. Okay, so I'll not use the sign language, I'll give you provide assent. Withhold assent. Okay, reserve the bill for president. And then subsequently the last one is that you can return the bill for reconsideration. Okay. Now with respect to the return for the bill, there has been a phrase that has been added to the constitution that basically says as soon as possible. That's the only phrase that has been added to the constitution. But with regards to any of these, there has been no time limit. Okay, no time limit prescribed. And this is exactly what the Supreme Court intended to say, that despite the absence of such time limit, there has to be some action that needs to be taken timely before it paralyzes the complete government. Okay. Subsequently, it is also written in the Constitution of India, if the bill is returned for reconsideration and it is repassed. Okay. So in that particular case, assent is obligatory. Assent is obligatory, but again no time has been given. No time limit has been given that when this particular thing needs to be done within a particular specific time. Now this is basically the shortcoming or loophole as of now in the constitution. Okay, no time limit is prescribed. So in both the cases, what is happening, that we basically see that because no time limit has been given, it is purely upon the discretion of the governor to consider any of these actions. And this in effect is the definition of pocket veto. When the bill is with you and you are not taking any action on it, you are not refusing assent, you are not providing assent, and you are not forwarding it to the president. Okay, so this is something which is given under Article 200. Now, in Article 201, under Article 201, now the bill is going to the president. Okay, so bill is presented to the president. So when the bill is presented to the president, so at that particular time what happens is that in this particular regard the president is going to be talking about the bill. Now the president has got two options, rather three options. The first one is provide assent. Okay, provide assent, withhold assent, and subsequently the last one would be that you would want direct the governor, I am writing governor GUV, okay, for the House's reconsideration. Okay. Now when the bill is provided to the House for reconsideration, again this is to be reconsidered within 6 months. To be reconsidered within 6 months. And then subsequently what happens, that this will again be presented to the president for the assent. Okay. Now the Supreme Court says when this is the situation, the president may provide assent or may withhold assent. But if the president is withholding the assent, now there has to be adequate reason that needs to be given. Okay, you cannot be withholding the assent without a reason. But these are the things that are not given in the Constitution of India. Okay, so that is basically the mismatch that has been there, which the Supreme Court is trying to resolve, and for this particular purpose we see that the presidential reference has become important. Okay, now talking about veto power. Okay, so veto is basically the authority to cancel a legislation, or decision. Okay, one of the two. Now when you talk about veto power, this is for the most part is most visible with respect to United Nations Security Council proceedings. Okay, so there are certain kinds of veto power which are there in the world. So when you talk about the types of veto power, okay, the first one is absolute, the second one is suspensive, third one is qualified, fourth one is pocket. Excuse me. So when you talk about absolute veto power, okay, so it is complete overriding of a decision. Okay, now this is something that we see with respect to the United Nations Security Council in the most visible form. Okay, the United Nations Security Council provides this kind of veto to the 5 permanent members of the United Nations Security Council. Okay, now the second type of veto. Okay, this basically talks about reconsideration of a bill, reconsideration of decision, and it can be overridden. Can be overridden by a majority. Okay, when you talk about qualified veto, so this is something which is available in the United States of America. Okay, so overridden by a greater majority, greater but specified majority. So this is basically something which is actually available with the President of the United States. Okay, so this is something which is given to the United States President. Okay, and finally pocket veto, where no kind of action is taken on the proposal that has been given to you. So you keep it pending indefinitely. So these are the four kinds of veto that are actually present with respect to the Constitution of India. There are interpretations. The Constitution does not provide any veto. The term veto is not there in the Constitution. Okay, not defined in Constitution. Remember this. Okay, but at the same time, when you talk about this particular veto power, now it basically means that in the Constitution of India we have a kind of absolute veto, we have a kind of suspensive veto, and we have a kind of pocket veto. With respect to pocket veto, you have just seen it. Okay, with respect to absolute veto, that is basically given to both President as well as Governor for private members' bill. They may or may not be given assent by the Governor or the President. Okay, suspensive veto is basically when you actually block a bill for reconsideration. That is suspensive veto. If it is passed again, you are obligated to pass it. We do not have a qualified veto. Okay, so this is basically all about veto power. Okay, now talking about the Supreme Court of India. So Supreme Court of India basically is the apex judicial body of the country. Okay, so we have a three-tier structure. Okay, at the top we have the Supreme Court. Okay, below the Supreme Court we have the High Courts, and below the High Courts we have the subordinate court. So this is the apex judicial body of the country. Whatever decisions or orders are taken by the Supreme Court, that has to be implemented and abide by all the you can say the junior courts. Okay, then at the same time, when you talk about the jurisdiction of the Supreme Court, okay, so this particular jurisdiction is basically divided in three parts. The first one is original jurisdiction. Okay, the second one is appellate jurisdiction, and the third one is advisory jurisdiction. Okay, so original jurisdiction basically means that Supreme Court will be the first court to try this particular case on its own. Okay, so for the original jurisdiction, that basically is related to the dispute between center and states. Okay, so between center and states, if there is any dispute, so they will go to the Supreme Court. The second one, dispute amongst the states. Okay, dispute amongst the state, just like Karnataka and Tamil Nadu were you can say fighting for the utilization of the waters of river Kaveri. So that was basically a dispute amongst the center. Okay, so amongst the states, and there could be others as well. There could be other disputes as well. Now they basically had their individual appeal with respect to the Supreme Court. Again, another example would be Maharashtra and Karnataka fighting over the territory of Belagavi or Belgaum. Okay, the third one. Okay, enforcement of fundamental rights under Article 32. Okay, I am writing FR. So this is Article 32, original jurisdiction of the Supreme Court. Okay, then at the same time, electoral petitions of President and Vice President. Okay, electoral disputes of President, I am writing PREZ, and Vice President. They are to be handled by the Supreme Court. Okay, then appellate jurisdiction of all the lower courts in India. Okay, for the orders that are passed by High Court, for certain orders that are actually given by the lower or subordinate courts, the tribunals. Okay, there are certain ways of appellate. So appellate basically talks about appeal. Okay, now the third one is advisory jurisdiction, which we just saw with respect to Article 143. Okay, so these are the three broad levels of the jurisdiction that is there with respect to the Supreme Court. Now with respect to the Supreme Court, this advisory jurisdiction, whenever it is giving its advice to the President of India, there needs to be at least 5 members or 5 judges bench. Okay, for this particular you can say reference. Okay, and this is something which is given under Article 145 clause 3 of the Constitution. Okay, 145 clause 3 of the constitution says that for the advisory jurisdiction purposes, or you can say overriding the decision or reviewing the decision that is taken by a smaller bench with a larger question of law or interpreting the Constitution of India, you would need at least a 5 judges bench. So that is why any such presidential advisory or reference is actually heard by a 5 judge bench of the Supreme Court. Okay, now that is given in the Constitution itself. So this is all about the Supreme Court as of now. When we want to discuss the Supreme Court, we will be discussing it in detail, because this particular year Supreme Court has completed 75 years of its institutionalization. Okay, it was established in 1950. This year 75 years have actually been finished. So we will be discussing it on a later date. Now coming to the questions. Test your knowledge. The first question was, consider the following statements about Article 143 of the Constitution. The provision empowers the President of India to seek the opinion of the Supreme Court on a question of law or public importance. Okay. The Supreme Court the Supreme Court's opinion thus tendered is binding upon the President. Which one of the above statements is or are incorrect? So provisions of the provision empowers the President of India to seek the opinion of the Supreme Court on a question of law of public importance. That is correct. This one is correct. But the advice that is given by the Supreme Court to the President of India is not binding on the President of India. So this is wrong. Okay, the President is not bound by the advice of the Supreme Court. So which of the following is incorrect? So with respect to the incorrect, only the second statement here is incorrect. Okay, so that is the correct answer to this particular question. Now the second question, consider the following statements about the advisory jurisdiction of the Supreme Court. It is mandatory for Supreme Court to tender its advice on every presidential reference. The Constitution of India provides for a minimum of 5 judges of the Supreme Court for hearing of a presidential reference. Which of the above statements is or are correct? So the first one, it is mandatory for the Supreme Court to tender its advice on every presidential reference. We have seen this is wrong. Under Article 143 clause 1, it is a discretion of the Supreme Court. The Supreme Court may decline. Not all the presidential references are going to be answered. Okay. Then at the same time, the Constitution of India provides for a minimum of 5 judges bench of Supreme Court for any hearing. This is correct. We have just seen it. Okay. So the correct answer again here would be option 2, because we are asking which of the following is a correct statement. So the second statement is correct. Okay. So let me know how many of you got both of these answers correct. Okay, in the comment section. Now talking about the second thing, Gyanex. Okay, now Gyanex is basically a series of exercises that have been experiments that are being conducted by ISRO, the Indian Space Research Organization, with respect to the Gaganyaan mission. So this is the question that you have with respect to ISRO. Consider the following statements about the Indian Space Research Organization. It is a constitutional body, that is the Space Agency of India. The organization serves under the Ministry of Science and Technology, Government of India. So we basically have to say how many of the above statements are correct. Now how many? Okay, how many? We have to count the number of statements. We do not have to choose the number or choose the statement. So be careful with the options. Okay. Now the second question, consider the following statements about the Gaganyaan mission. It will be India's first human crewed space mission to the lower Earth orbit. The mission will last for 14 days after the launch. Which of the above statements is or are correct? Now deliberately I have given this question so that you can distinguish. In the first question you needed to count the number of statements which are correct. Here you have to choose which of the statement is correct. Okay. So pause the question. Okay. Now you may pause, and now you may pause. Okay, and now try finding these particular answers in this particular session. Talking about Gyanex. So Gyanex basically is a short form for Gaganyaan Analog Experiments. Okay, so they basically are called as Gyanex. And the ISRO, Indian Space Research Organization, which is India's apex research organization, the India's National Space Agency, which was established by a government resolution, or it is an executive body in 1962. rechristened as ISRO in 1969 and since then has been functioning. Okay, so when you talk about ISRO, so it is basically an executive body. It is not a constitutional body. Okay, so with the name ISRO, okay, so it was named ISRO in 1969. Okay, and it was launched, it was formed as INCOSPAR. In 1962. But this is a government body, not a constitutional body. Okay, now ISRO is India's national space agency, and ISRO is as of now trying to demonstrate the human space flight, and that is something which is done using the Gaganyaan project. That is what we are trying to do with respect to the Gaganyaan project. Okay, so before this particular project could take off, we need to conduct a series of experiments even with respect to the astronauts. Okay, so the Gaganyaan analog experiments basically talk about these experiments. So they basically are trying to simulate the environment of the space and the environment of the module in which these particular astronauts would be going to the space, and then subsequently conducting experiments. Okay, so these particular experiments are being conducted in order to formulate the protocols for handling emergencies. Okay, then at the same time it will also be utilized for research in space medicine. Okay, what kind of you can say the things are required in space medicine, because you may fall ill anytime, anywhere, and the bodies are going to respond in a very different manner. Okay, then the next thing that is basically being done is to design selection criteria for future astronauts. So these are basically the various kinds of objectives of this particular mission. Then at the same time also analyze physical and mental stress or physical and mental conditions of astronauts in space. So these are the broad objectives that this particular GANX series of experiments are going to happen. Okay, and a part of this experiment has already been done. Okay, a new series of experiments have currently being commenced, and a continuous gathering of data is taking place. Okay, so this is something which is being conducted as of now in Bangalore. So at Bangalore as of now we have the separate cell for Human Space Flight Center, HSFC. Okay, so it is called the Human Space Flight Center, which basically is handling all the training related aspects and development of the Gaganyaan project. Okay, and with regards to that, what is happening is that there are 4 astronauts that have been selected. We'll be seeing their picture as well. Okay, and they are basically the ones who are expected to carry out the experiments that are to be done with respect to the space when they go into Gaganyaan mission, and then at the same time also carry out regular activities that they would be doing during the mission. Okay, so for that these series of experiments are being conducted. Okay, one of the major aspects is to evaluate the mental condition of the astronauts in the space. Now remember how exactly we all felt when we were actually locked down in our homes or wherever we were residing during the time of lockdown of COVID-19. Okay, so that was something which created very dull and depressing feeling for ourselves, because we were all under a kind of solitary confinement, and it was even worse for the people who are actually frontline workers. So that is why what happened was that it created enormous amount of stress, despite the fact that you could actually see and meet the people who you actually care about. But when you are in space, it is even worse. Whoever is there downstairs, or that person is on the earth. You are somewhere suspended in the space. Okay, you do not have a place to sit, you do not have a place to talk, and subsequently there is always a risk of fatality or accidents. So the stress is something which is enormous. And despite this particular stress, what also happens is that you have to carry out certain experiments with precision. Because if any of the experiments are done wrongly, it is going to significantly impact the entire line of design of experiments or the human space flight ambitions of India. So that is why this is something which is very, very properly taken off, so that the human aspect of the Gaganyaan project can also be evaluated. Okay, so that is basically the GANX series of experiments that we have. Okay, now talking about the Gaganyaan mission. So Gaganyaan mission is basically the mission which will be a demonstration mission. So first of all, we need to be very, very clear that it is a demonstration mission. Okay, what exactly is it going to demonstrate? It is going to demonstrate a human space flight by ISRO. Okay, so this basically means that there will be a crew that will be taken to a low Earth orbit. Will be taken to a low Earth orbit. Okay, the altitude would be 400 kilometers, where currently we have the International Space Station. Okay, so they will be taken on a low Earth orbit, LEO. I have written it that way. Okay, and they will be there for 3 days. That's the first part. Launching a crew to the low Earth orbit for 3 days and then bringing them back safely. Okay, these are the two aspects of the Gaganyaan mission. So it will only be a demonstration. It will not be a mission that is going to last for more than 3 days. Okay, if everything goes well. And then at the same time, what also is the thing is that based upon the data that will be collected during this particular mission, what is going to happen is that India will be planning its own space station. Okay, India's own space station, that's the first thing. Okay, and then at the same time, its own lunar mission and interplanetary mission as well. Okay, so with respect to the interplanetary mission and lunar missions, okay, we are actually utilizing the terrain of Ladakh very, very extensively. Okay, so with respect to this particular thing, there are 2 experiments that are actually ongoing in Ladakh. Okay, one of them basically is going on in the Sokar Valley. Okay, and the other one is basically taking place at a barren highland. The location has not been disclosed. Okay, so the Sokar Valley experiment is basically simulating the conditions of Mars. Okay, and this one is basically for a interplanetary base. So we are also moving into that particular race. So in the Sokar Valley, it has been seen that in this particular valley, because of its high altitude, there is enormous amount of ultraviolet radiation influx. The second thing, the permafrost here, the soil here which is permanently frozen is saline, which is very, very similar to the initial conditions of Mars and also the low temperatures which prevail here. With respect to this barren highland, that is again in Ladakh. So that is something where we basically are trying to understand what exactly are the kind of materials that will be required to build up human dwellings in an interplanetary mission. So here we basically have built up a human dwelling, and subsequently the astronauts are also sent there to evaluate what exactly are the conditions and situations of living here. Okay, so this is basically the Gaganyaan mission in a nutshell. When you can say this particular mission would be launched, which is basically expected for 2026 or first half of 2027. We will be having more information on this. As of now, this is basically the information regarding it. Now, when you talk about the Gaganyaan crew module, which is basically the one which will house the crew, Okay, so the crew basically is going to be housed in this particular you can say thing. Okay, now what you are seeing here, this entire module is called the crew module. Okay, and this is basically the emergency escape hatch. Okay, this is basically the emergency escape hatch. So during the launch, if there has been any kind of mishappening that happens to the launcher, so this entire crew would then subsequently be taken into another nozzle-like module, and from there the crew would be safely brought to the ground. So that is a safety precaution. If everything goes well, then this is where the Gaganyaan module would be taking, the experiments will be taking place. Now with respect to the module, it will have two parts. The first part will be the crew module, where the crew is basically going to be located. This is where the crew is going to be. Okay, that is what you're seeing here in reality. And this is basically going to be the service module, which will house the propulsion system, the power system and solar panels for the entire module. Okay, so that will be attached in the other part. And this particular thing is going to be tested for 3 days in space. Okay, so this is the crew module. Okay, this will be mounted atop the launch vehicle Mark III, okay, which is now human rated. Okay, so this is basically the GSLV. You might be seeing that GSLV is written here Mark III. Now it has also called the launch vehicle launch vehicle Mark III, LVM3. So now it has been human rated, meaning that it has been tested for carrying this particular you can say crew module to the space and then subsequently leaving it there discharged. Okay, so that is basically what has been there. So the first test of this entire crew module has taken place successfully in 2024, and this is how the crew module came back. But this was completely unmanned. Okay, this was basically unmanned. So this particular module was actually you can say dropped from an altitude of 17 kilometers. Okay, and from an altitude of 17 kilometers, it basically came back on the surface of the earth and landed in the Bay of Bengal, and subsequently it was retrieved by the Indian Coast Guard. Okay, so this was basically the launch and this is the retrieval. Okay, 18th of December 2024, this is what happened. So now we have attained the full capabilities of launching this particular vehicle with the humans. Now the entire development is focused here, the safety. Okay, so this is basically what is called as the payload. So payload is basically what you want to deliver to the space. Okay, so till now ISRO has actually had all the satellites which it wanted to deliver, either for itself or for foreign clients. Now this payload will have this crew module. Okay, I hope this is something which is clear. Now these are the 4 astronauts who have been selected for this Gaganyaan project. Okay, so so we are going to have their name. Okay, so this particular astronaut is Prashant Balakrishnan Nair. Okay, this gentleman is Ajit Krishnan. Okay, so these are the 2 astronauts. The next one is Angad Pratap. Okay, and the fourth one is Subhanshu Shukla, a very famous you can say personality as of now. Okay, you might be knowing him or you might have seen him. Okay, why? I'll just tell you. Okay, so Subhanshu Shukla, okay, this particular individual was the pilot for Axiom 4 mission. Axiom 4 mission to the International Space Station. Okay, it is called ISS, International Space Station, and he has been the first Indian to go into the International Space Station from ISRO. So why are we not considering Sunita Williams? Because Sunita Williams actually went from the space agency NASA. She was not from ISRO. But Subhanshu Shukla is the first Indian from ISRO to board the ISS and spend time there. Okay, he has now safely returned to the earth, and he is as of now the most important asset with respect to all the data that is required, because one major aspect of GANX mission which is missing is that it is not having microgravity situation or absence of gravity. It is very difficult to recreate on the surface of the earth. Okay, so there has been, you can say, no situation in which gravity can be completely reduced to negligible values on the surface of the earth. Okay, so for the Axiom 4 mission, okay, Subhanshu Shukla and Prashant Balkrishnan Nair were selected, and these two were trained for about 5 to 6 months in the United States. Okay, and from these two, Subhanshu Shukla made it to the space while he was the backup. Okay, so these are the 4 Indian astronauts that have been selected for the Gaganyaan mission. Okay, now coming back to this particular question, ISRO. Okay, so I will be answering the second part. I know that I have not answered it yet, so I will tell you now. So when you talk about ISRO, consider the following statements about Indian Space Research Organization. It is a constitutional body, that is the Space Agency of India. It is wrong. Yes, it is definitely the Space Agency of India, but it is not a constitutional body. It has been created by the government based upon its own resolution. Now the second thing, the organization serves under the Ministry of Science and Technology, Government of India. This is wrong. Okay, ISRO actually serves under Department of Space. Okay, Department of Space, and this particular department comes directly under the Prime Minister's office. Okay, so it does not serve under the Ministry of Science and Technology. So the correct answer here would be that both the statements are wrong. So neither one nor two. Okay, the next question. Consider the following questions about the Gaganyaan mission. It will be India's first human crewed space mission to the lower Earth orbit. That is correct. The mission will last for 14 days after launch. This is wrong. It will be only for 3 days. So the correct answer here would be A, one only. Okay, so that is all about Gaganyaan. Now let's move towards the graphite spyware. Okay, so we are going to discuss what exactly is graphite spyware. So when we talk about graphite, okay, this has been in news for 2 different reasons. First, that the Canadian University of Toronto Lab of Forensics, they basically have confirmed that this particular spyware was used to spy over 3 prominent journalists of the European Union, one of whom was Cairo Pellegrino, and the other European journalist was the one who did not wish to be named. Okay, so it was confirmed that they have been targeted using this particular graphite software. Okay, now the second reason why it is in news is because it is something which is going to be procured by the United States of America. Okay, procured by the United States of America for its immigration and customs enforcement. Okay, for Department of Immigration and Customs. Okay, so this is something which will be procured by the USA, and it will be given to this particular department in order to keep track of all the immigrants who come into the country, and at the same time the individuals who are actually dealing with imports and exports from the United States of America. Now this particular you can say procurement, this was something which was you can say frozen or cancelled by Biden administration. Okay, so Joe Biden, who was the former president of the United States, he basically froze or cancelled this particular contract because at that particular time Apple had already you can say informed these journalists about the spying that was being done, okay, over their particular phones. So this is a blatant breach of privacy of the journalist. So the Biden administration froze this particular contract. Now this particular contract has been reopened by the Trump administration. So the current president of United States, Donald Trump, basically has given a green signal for procurement of this particular software. Okay, so when you talk about this particular spyware which is in news, this is basically developed by the company called Paragon Solutions. Okay, it is developed by a company called Paragon Solutions, which has been incorporated in Israel. Okay, it is actually a company of the former Prime Minister of Israel, Ehud Barak. Okay, so that is basically the concept here, that Paragon Solution basically is incorporated in Israel and it was purchased in a $900 million deal. Okay, 900 millions by a US group recently. Okay, now as per the Paragon Solutions, which is basically this particular company, it says that it provides this particular software only to legitimate governments and law enforcement agencies to curb crime. Okay, so that is basically the objective that is purportedly given by Paragon Solutions. Okay, but this was something which was given as a way of managing the media after this was proven by the analytics report that yes, the iPhones of the European journalists were actually hacked, or they were being spied upon using this particular thing. Okay, now what has happened is that this particular spyware, okay, so this particular spyware was maliciously installed. Okay, it was maliciously installed into the iPhones. Now this particular spyware was actually being infecting the iPhones. Now you have to be very careful about this particular thing, that most of the spyware attacks that are coming into the news are basically coming from the iPhones. Now there are two reasons. One, most of the people who basically are high profile, they use Apple devices because they trust the security. Second, Apple also reciprocates by continuously taking a you can say a survey of what exactly are the vulnerabilities in its operating system, and subsequently it comes up with such reports whenever it finds any kind of anomaly. So Apple on its part accepts it, and subsequently it comes to the news that okay, iPhones are the ones which are getting targeted. Android as of now has not said this. Now this is basically a marketing tactic, plus at the same time it may also be the case that most of the you can say high profile individuals do not go for Androids. Okay, so that is basically a psychological play, nothing for us to be concerned about. Now we need to understand what basically is a spyware. Okay, so spyware, going by the name, is basically a particular software which is installed without the consent. First of all, it will be installed without the consent of the user. Okay, and now what exactly is it going to do? It records all the activities being done by the victim. Now these activities could be anything. Okay, these could be messages, these could be bank transactions, media sharing, okay, so it will record all these transactions. At the same time, it can also use the microphone and camera. Microphone and camera as a recording device. To spy not only on this particular victim but also on others with whom this particular individual is actually interacting with. Okay, so this is basically what is a spyware, and the entire concept is that it is done without the consent of the user. Now there are two ways of doing this. Okay, the first one is basically called phishing, and the next one is basically called zero-click exploit. Okay, so in phishing what happens is that you are lured into a very genuine looking and very reasonable kind of offer, website or app. Okay, you may be asked to you can say purchase a particular subscription. You may be given a very intriguing or interesting kind of app for certain of your very important needs to be done, and that is something which is called phishing. So basically what happens is that all this information is actually then transferred. Okay, sent to a remote location or sent to a remote owner, who then records this particular information and then subsequently may use it for identity theft, financial bankruptcy, for that matter blackmailing, okay, victim manipulation, anything. So first of all, phishing is something which is done based upon your vulnerability. So what happens is that sometimes when you're actually surfing the internet, you are browsing your social media, there are certain things that you actually tend to look more frequently, okay, and subsequently what happens is that the algorithm reads this and it starts pushing more of that content towards you, okay. So basically one such way is basically using adwares. Okay, adware is basically advertisement. So they are harmless as of now, but at the same time what also happens is that they basically give you the advertisement of those things that you may be talking about. Now the horrifying part is that you may not have even searched it, you might have just spoken about it with someone, and even then sometimes you find that this is something which pops into your social media feed. Why? Because you have given access to your microphone and your camera to the social media and they are always listening, okay. So that is one way. The next way is basically you may have been given a very intriguing offer of something which is of dire need for you, maybe a personal digital assistant, maybe a kind of you can say complete access to some kind of premium encyclopedia, and you basically click on that particular link, okay, and then subsequently you are duped. By looking at a very genuine kind of website, you are actually duped and your credentials are then taken away and the spyware gets installed by the person because now they have their password, your password is with them, so they basically install it. That is the usual approach, but this is basically the more important of the beauty, because here zero click exploit basically means there is no need of the user to take any action. Okay, even if the user does not take any action, even in that particular case what happens is that the spyware is going to be installed, okay. So here basically what happens is that a remote vulnerability of the operating system is exploited, of OS is exploited, and subsequently what happens is that based upon this your entire phone's access goes to someone else. It is not just limited to phone, it can be your device, laptop, tab, anything, okay. So that is basically what is a spyware. So spyware is a class of malwares, okay. So this is basically a type of malware. So malware is basically the short form of a malicious software, a software that has been designed with not benign uses but with malicious intent, okay. So this is basically done in order to blackmail you, get money out of you, okay. So all the kinds of things are basically malware. One of that type is spyware, and when you talk about spyware there are a lot of different types of spywares, okay. You may be knowing Trojan horse, you may be knowing as remote access toolkit, okay. So these are basically all spywares. So this is exactly what happened with respect to you can say Paragon as well. So here the graphite spyware was found to be maliciously installed using the iMessages in these two phones. After this particular software was installed, now the data from both these phones started to go to the attacker, you can say the individual or the entity that was you can say controlling this particular account, and from there a connection was found to the server. Now this server is basically the one which belongs to Paragon Solutions, and hence it was established that using this particular spyware the European journalists were actually being spied upon, okay, by the person whose identity has not yet been known. Okay, so that is why even if this has been established that yes, spyware was used and this particular journalist was targeted, the individual who was targeting them is not yet known. Okay, so this is basically the spyware. Now let's move towards the last topic, and that is autumn equinox. So when we talk about autumn equinox, this particular picture in itself says a lot. Okay, so equinox basically comes from the Latin word nox. Okay, so nox basically is a Latin word which means night. So equi basically means same. So basically on equinox the occasion is that the day length and the length of the night is going to be almost the same. Okay, so equal length of day and night is basically the day of equinox. It happens 2 times, okay, throughout the year, one in March and one in you can say the September. So today is basically autumn equinox of 2025. Why exactly is it called autumn equinox? From this particular day onwards, we say astronomically that the autumn season begins in the northern hemisphere. Okay, so now we are going to transition from summer towards winter. Okay, so in this particular scenario, what happens? The sun starts taking its trajectory, crossing the equator. Okay, so when you talk about the apparent movement of the sun with respect to the earth, so basically what happens is that now the sun is going to be shining more towards the southern hemisphere than the northern hemisphere. So it means that in the northern hemisphere we are going to now experience winter, while there will be summer in the southern hemisphere. So in this particular occasion, the autumn equinox, what happens is that the axis of the earth, okay, the axis of the earth is neither tilted towards the sun nor it is tilted away from the sun. So both the north pole as well as the south pole, they both are at a similar inclination, and that is why all the rays of the sun basically are going to be traveling the same amount of distance, and we are going to find an equal length of day and night. Okay, and as you move away from the equator, the difference in the extra amount of daylight is something which becomes more pronounced, because on the equator, on most of the occasions, the sunlight remains direct throughout the year. So that is why on the equator you do not find a serious change of the length of day and night. Okay, but as you move towards the pole, the difference could be as much as 20 minutes. Okay, so 20 minutes could be the difference. Then that is basically how the autumn equinox and the vernal equinox are seen. So autumn equinox basically is basically said to be in September. Okay, whereas when you talk about the vernal equinox, this is basically the one which happens in March. So when it is autumn equinox for the northern hemisphere, it is vernal equinox for the southern hemisphere, because there the season is now going to transition from winter to summer. And for us, the season is now going to transition from summer to winter. And why is this happening? Because of the inclination of the axis of earth. Okay, so the axis of earth is inclined at an angle of 23.5 degrees with respect to the vertical. That's the first thing. Second, when it is revolving around the sun, so there are occasions when the north pole actually is closer to the sun, or the northern pole is tilted towards the sun, and on other occasion the southern pole is tilted towards the sun. So whichever pole is going to be tilted towards the sun, that hemisphere is going to experience a summer season. So now we are transitioning in that particular scenario, and this is basically what happens. Okay, so during the time of summer season, this is basically the north pole's position, and this is the south pole's position. So you can see that the north pole is relatively closer. Okay, on the other end, when you talk about the winter times, so here basically what happens is that this is the north pole position and this is the south pole position. So here you basically see that the sun is closer to the southern hemisphere, and on the first case the sun is closer to the northern hemisphere. So what happens is that in this particular time, you basically see that this is basically the hot time. Okay, so hot season for north and cold season for south. Okay, and in this particular half of the year, it is basically cold season for north, okay, and hot season for south. So that is why we see that the you can say the Christmas, the festival of Christmas basically is celebrated in winter in the northern hemisphere, but in summer in the southern hemisphere. Okay, so what basically happens is that because of the tilt of the axis of the earth, we have these particular seasons. And now let me also tell you that the concept of equinox is not just related to earth. Okay, so equinox is not unique to earth. It will happen in all those planets which are tilted at certain angle from their orbital plane. Okay, so all the planets which are tilted with respect to their orbit, they are going to experience the conditions of equinox. And one of the most brilliant one is basically in Saturn. Okay, in Saturn's equinox, when you talk about Saturn's equinox, the rings of Saturn disappear because of the shadow that is created. So these rings of Saturn disappear. So remember this. This is a fun fact for you. Okay, so that is all with respect to equinox. So equinox and solstice are two different movements of the earth. Okay, so throughout the year when the earth is actually traversing an elliptical path around the sun, we basically see that there are 4 such occasions. 2 occasions on which the length of the day is longest in the north hemisphere and the shortest in the southern hemisphere, that is called solstice, the summer solstice. And 6 months later, this is something which happens in the winter just before the Christmas, that there is the longest day of southern hemisphere and shortest day in the northern hemisphere, that is called the winter solstice. Okay, and there are 2 other occasions in between during March and September that the length of day and night almost throughout the earth is same. Okay, so I hope all of these facts are clear to you and you could understand them properly. So we will end this particular video, and let me know how exactly you found this particular video, and take detailed notes. You will be supplemented with notes from our Telegram channel. You will also find this in the website. If you have missed the previous lectures, you will also find a compilation of all these notes as well as the videos in our channel. So please do make sure that you are actually taking care of watching these videos, because we are taking care of your current affairs demands. So please like, share and subscribe, and we'll meet again. Till then, take care and study hard. All the best.